Okay, welcome back. Our next panel is on trade secrets litigation, which at a conference on patent litigation might sound a little odd, but I think trade secrets are the new patents, right? So we're going to hear about trade secrets both as an alternative to and as a complement to patent litigation. Our moderator is my Dury Tangri partner, Josh Lerner, and I will have him introduce the panel.
Thank you. Since everyone's bios are in the packet you've received, I'm not going to spend too long on them, largely because I don't actually want to take away time from this panel. Mark and the Stanford crew managed to gather a lot of kind of the leading lights on trade secret litigation, so I really do want to give you the chance to hear from them. Very quickly, Neil Chatterjee has been one of the best known lawyers in Northern California and across the country for a long time now. I'm sure you probably remember the Winklevoss litigation, and fast forwarding to much more recently, has been involved with representing Lewandowski in the Umer-Waymo dispute. So obviously, high-profile cases involved at all phases, and as you'll hear today, can discuss all phases of trade secret litigation and how that interacts with patent litigation. James Pooley, I'm sure, has heard moderators of discussions say about 500 times, so I will make it 501, that he wrote the book on trade secrets. It's actually called Trade Secrets. He wrote it, and it's not an exaggeration to say that if, like me, you practice trade secret law, you have a copy of his book on the shelf and you pull it down regularly, and when younger lawyers come to you and say, I have a question about the following in this trade secret case, you get tired of saying, here's the book. James is consulted not only on active litigation matters, but on policy. When you read about new legislation or considered legislation, you will often see James' name pop up. We're also joined by Ken Greya. Ken has been a senior vice president and head of US IP at Samsung since 2011, I believe, and his experience likewise spans across all flavors of IP, patent, trade secret. He's got 24 years of experience in these types of cases. And I think the thing I want to close with before we start with some specific topics is when we spoke as a group beforehand, Ken really highlighted something that I think people fail to devote enough attention to in these discussions, which is trade secret cases lend themselves to hot emotions at the outset. People are often very worked up when you file one of these or when you receive one. They engender strong responses. That's not always the same set of feelings that people have 1, 2, or 3 years later when you finally end up at trial and there have been cross claims and there's been extensive discovery and everything else that goes along with trade secret litigation. And one thing that Ken really helped us think about, and that I think all of us will talk about a little bit as we work through these topics, is just what are the intended and unintended results of filing trade secret claims, either standalone or with patent claims, because they do differ in terms of the consequences. So to jump in, the first thing I wanted to start with today was a question for James, just to start us off, which is the trade secret litigation that we see right now is often international. It's often got an international flavor. And one question that is coming up is, are we going to see U.S. trade secret law applied to ex-U.S. misappropriation? And so with that, I'll jump in and let Jim take over.
Yeah, thanks, Josh. And this is a really interesting question, in part because in contrast to patents, trade secret laws are not as such territorial. Yes, they're expressed in national laws, but they apply not to a government-granted right, but to a relationship of trust through which information has been shared. Most often that is, and sometimes it's about espionage. But the point is that that relationship can travel around the world, and the acts that we're concerned about, acts of misappropriation, can happen anywhere and have an impact someplace else. When the Congress was considering the Defend Trade Secrets Act a few years ago, it ultimately decided, for reasons of political reality, I guess, that it wouldn't expressly say something about extraterritoriality. However, if you read the uncodified provisions of the Defend Trade Secrets Act, you will find strong expressions of congressional understanding and intent that any U.S. information that is misappropriated abroad necessarily causes economic impact here in the U.S., loss of jobs, etc. So there, you can't have any doubt when reading what it was that Congress did that they were concerned about this. They asked for reports to be sent to them periodically about what was being done and the impact of foreign misappropriation of U.S.-owned trade secrets. So this is clearly on everyone's mind, and of course we know that with business having become essentially globalized and information being stored and transmitted digitally, around the world, the opportunities for this sort of thing are much greater. Now, but what actually has happened as a result of this? What do we see? Well, because the trade secret laws vary to such an enormous extent in terms of their practical enforceability around the world. And for this, if anybody's interested, I suggest a 2014 OECD report that comparatively examines most countries in the world and rates them on a scale where you have U.S. and Canada at the front and China and Russia at the bottom. Anyway, the variability of enforcement means that the question of getting trade secret enforcement here in the U.S. over something that happens somewhere else is really important, because as a practical matter, in most jurisdictions of the world that operate under a civil law system, you can't get access to the proof of what happened. And in a trade secret case where misappropriation rarely happens in broad daylight, that is a really important thing. So being able to sue here in the U.S., very, very important. How clear is it that you can do it? Not so clear, because despite what it was that Congress said, the Defend Trade Secrets Act was an amendment of the pre-existing Economic Espionage Act that begins at Section 1831 of 1830 of 28 USC, and that act contained when it was passed in 1996, was focused only on criminal behavior. And it has a section 1837, that it addresses territoriality specifically. And it says that this law will apply to any offense committed in the United States, any part of which was committed in the U.S., or when one of the offenders was a U.S. citizen or permanent resident. And so there's something of a limitation on an otherwise broad grant of extraterritorial effect. Now, the general rule is that federal laws do not have extraterritorial effect unless congressional intent to the contrary is clear. Well, that was pretty clear for the criminal laws. Now, what happens when you amend this title, this portion of 28 U.S.C., and you provide civil remedies without clarifying and without changing the wording of this pre-existing Section 1837? What happens is you've introduced ambiguity. One court so far has addressed the issue in passing and has basically said, oh, well, 1837 must apply to Defend Trade Secrets Act claims, civil claims. But we don't really know. It is certainly possible that a judge could conclude that because of the language of 1837 and its history, it would not apply to claims made under the Defend Trade Secrets Act, civil claims, and that there's no extraterritorial effect because congressional intent doesn't sufficiently appear. Or you could get a judge who says No, I read all of this that Congress wrote into the bill, and it seems pretty clear to me that they were worried about this, that they want it to be applied extraterritorially, and so it should, to the extent consistent with the Due Process Clause. It's very interesting to me that we're more than 2 years into this new statute, and we don't yet have a thoughtful treatment of it, but it's going to come.
Can I ask I just, hearing what you had to say, Jim, can I ask you a question that we didn't rehearse in advance?
We haven't rehearsed any of this.
That's right, it's completely unrehearsed. So one issue that I've had in the back of my mind with these extraterritorial cases is instead of saying the Defense of Trade Secrets Act applies for activity occurring abroad, entirely abroad, could you assert a claim in the U.S. for something tied to the U.S. and then assert a supplemental jurisdiction claim? You came to a patent class, and we're talking about trade secrets, and now I'm taking it down to federal courts. Could you assert under supplemental jurisdiction a foreign trade secrets claim? I've never seen that case,
Yeah.
but I don't know why you couldn't.
Don't know why you couldn't. Well, I think we've seen in the patent arena, judges loathe to enforce foreign patent rights.
That's true.
Here. And I think some of that same reluctance may appear if you were to try to present it in the trade secret context. I think the reason that you probably won't ever see it is because there isn't any particular reason to. If the court's arm is going to reach far enough to grasp the foreign law and try to import it here, that judge is not going to have any problem asserting jurisdiction over the actors and applying to them, applying to their conduct to the extent that it's consistent with notions of due process, our own law over trade secrets. There's typically, what you see, if you go back and look at the 2011 Chan-Ri case before the Federal Circuit, now that was an ITC case, and so it was in a sense easy because it wasn't about in personam jurisdiction, it was in rem. But the court took a look at it between the law here and the law in China. First of all, they said there's a federal common law on trade secrets, which was kind of an interesting proposition. But they also said, look, there's no real conflict. So from between our laws and the laws of China, because they're pretty much the same. And at a superficial level, they certainly are. I mean, we're all members of the WTO and TRIPS and the TRIPS agreement, and TRIPS pretty much states law that is consistent with our own. So we don't really have a conflict. Comedy is not going to get in our way. So I suspect that the issue is really going to come down to jurisdiction. It may not play out exclusively in federal court. I mean, there may be state courts that feel that their long-arm jurisdiction works for them.
And just to provide a small amount of context on this, if you don't spend all your time reading the background on the DTSA, you heard Jim mention 1996, and then obviously we have the passage of the DTSA also in a national election year. The trade secret acts, at least recently, have been passed in national election years, and not surprisingly, as was explained, they have therefore come with a whole lot of commentary from the legislators that's often pretty strong and some would say inflammatory. I think an important point is that a judge looking at that, particularly, you have to account for the fact that this will be nationwide, could look at this legislative history and say, I'm sorry, the example that was given here was an example of a person from China getting on a plane and leaving with trade secrets. That was the example given as kind of the motivation for this act, which is actually something that was said. If that's something that is said, you could certainly see a judge concluding that they think perhaps there was an intent that this should apply ex-US. So it's I think important to kind of have that context for the recent passage. It also was passed very quickly. If you want kind of two ends of the spectrum. Sarbanes-Oxley and the comment period there is at one end, and DTSA and how quickly it was passed and the comment period there is at the other end.
Well, that's true. Although, I recall in 1996, the Economic Espionage Act was passed within 3 months, beginning to end. The DTSA resulted from several predecessor bills that had been considered in the previous Congress, and so it was a much longer process of consideration. And although, yes, you're right, there was this discussion about, the person picking up something here and leaving and going to China, that was mostly about the seizure provisions, which were extremely controversial, and since the law was enacted, hardly ever used, even though they sucked most of the oxygen out of the room during the discussion. But I would just say that, here's an interesting aspect of, how sausage is made. When I saw the original bill, the Senate bill, I asked the Senate staff, well, why haven't we treated extraterritoriality expressly? We have this issue here, and they said, we can't. As a political matter, we can't put it out there so everyone can see it and say, we're having the U.S. federal government, reach out to foreign countries. It won't go down well politically. And so at the same time, everybody has this feeling about it, and so we've done the best that we can do by throwing in all of this language that I told you about before. So there we are. It's intentional ambiguity.
I want to hop around a little bit and jump from international matters to much more granular matters, which is the identification of trade secrets. Neil, I know you have been involved, and this kind of has the interplay with the patent litigation side. You've been involved in, for example, the local rules on infringement contentions and everything else from early on until today. And I'd love to hear a little bit about your experience in terms of what's happening now with the requirements for identifications of trade secrets and how you think that's perhaps been influenced by some of the history on the infringement contentions and general patent rules here.
Yeah, well, for those of you who have not spent a lot of time with the Defense of Trade Secrets Act, one of the big things about it is it doesn't require a reasonable identification of trade secrets like you see under the California Uniform Trade Secrets Act. So in California, there's this obligation under section 2019.210 that is a threshold before you can seek discovery. You have to disclose with reasonable particularity what your trade secrets are. And many courts around the country, while they don't have that provision, they still impose that kind of a standard as a gating issue. And it's really tied to the fact that you don't want to put your trade secrets in a pleading. Like if you put it in your initial complaint before it's ever been filed under seal, you run into this risk of it being publicly disclosed. So they thought, okay, we're going to hold people's feet to the fire through some sort of pleading option. When DTSA came out, I think there was a lot of conventional wisdom, although it wasn't universal, that standard would apply in the trade secrets context. So even if someone didn't specify their trade secrets in the complaint, that as the threshold to proceeding with the case, they would be required to describe their trade secrets with reasonable particularity. It turns out a lot of courts have said that, but a lot have not. And there is an open question, currently unresolved by any appellate court, as to what is the gating consideration. Now, here in the Northern District, there has been not uniform, but a fairly substantial set of courts that have not only said you have to define your trade secrets with reasonable particularity, but some courts have gone so far as to say you have to give infringement-like contentions about what the misappropriation is. And if you look around the country in terms of the disclosure requirements for trade secrets, how quickly people need to be pinned down as plaintiffs, it actually tracks pretty substantially what that particular jurisdiction's philosophy is on infringement contentions. So for example, a lot of people are filing trade secret cases in Delaware. Why? Well, in Delaware, only some judges apply the infringement contentions for patent cases, and they normally allow for amendment pretty liberally. And as a trade secret plaintiff, with that same concept in mind, even though it's a different legal domain, it gives plaintiffs a lot of flexibility to kind of adjust their trade secrets depending on what their strategy is. And the judges will not typically require, a lot of real sharp and clear contentions at the outset. And so that, I've seen at least a rise of trade secret cases being filed there as a result.
Yeah, I generally agree with that. However, we have to be really careful not to conflate the issues of identification and when and what the consequences are, what the gating issue is. I think,
I agree.
I think it's a relative minority still of all jurisdictions that require a particularized identification before discovery can start. Most jurisdictions, particularly federal courts, see this as, basically something for a Rule 16 conference, and we all need to understand what the subject matter is early on. And then, as far as the contentions around misappropriation, most jurisdictions see that as something that unfolds in discovery and don't require it. This, here in California, we've been substantially influenced by over 30 years of experience with 2019 and its predecessor. And that, and then the views of some individual federal judges who are used to handling patent cases, who decide that the level of particularity you need is the same as in patent claims. That's not the majority practice, but
Yeah, the level of specificity here in the Northern District is way more exacting here in this district.
depending on which judge you get, right? Some are much more forgiving about that, and about the amendment issue, et cetera. This is something we're looking at in the Sedona process now, and we hope to come out with some good, reasonable consensus practices.
So Jim, as somebody who has represented defendants in trade secret case, it's to me that if a plaintiff does not show or identify what the trade secret is, it makes it very difficult for you to defend yourself. In a patent case, you have a patent that's being asserted against your product, so at least you have the basic parameters that you can prepare your defense. Whereas a trade secrets, unless it gets identified, it basically increase the amount of money you have to spend in defending yourself. So why is that in DTSA you guys decide not to include identification of trade secrets?
Yeah, I mean, your concern is absolutely right in the abstract, but of course, like many other things, the devil is in the details, and those of us who were around when 2019 was introduced in 1985 remember the chaos, the disaster that happened in the several years following that as judges halted discovery in cases where, as you can appreciate, as I said earlier, most trade secret cases, the plaintiff doesn't know everything that happened ahead of time, needs to get access to discovery in order to pursue its case. So everything got halted while there were serial motions attacking the sufficiency of the trade secret identification. And so this turned into a tool that was relatively easy for defendants to abuse until we got some better direction from the Court of Appeal about how this should actually be handled in a kind of a rational way. Now, why wasn't it in the Defend Trade Secrets Act? It's because California and just a few other jurisdictions have adopted this blocking discovery until you get it right rule, and there are a lot of people who saw the downsides of that process and felt that it would be a lot better to leave this up to federal courts to determine as they do other discovery issues in a balanced way. So, yeah, there wasn't really a much of a press for it at all. I mean, we got very substantial push on the issue of inevitable disclosure, but not on identification.
The weird thing about this whole identification issue is that the blocking issue is not, that's the way the statute's defined, but what the goal of that statute is is to frame discovery so it's not a fishing expedition, right? That is what the goal of the statute is, but that isn't how it's fought about, right? I mean,
You understand, I think fishing expeditions are exactly what discovery is all about, but.
and we are all well employed for it.
But yeah, the goal is to inform the defendant and the court so that they know what's happening. But here, Ken, here's an example of why that doesn't always work very, very well. Frequently, if you have people who've been involved in R&D, they leave, they go to a competitor, you have a massive amount of information that potentially they might be using. And if you were asked to identify it all at a real deep level of granularity, you'd be doing that for years, right? Whereas if you get a bit of discovery and you know what is or isn't at issue, then you're in a better position to be able to describe that with greater particularity. So sometimes these things have to be iterative.
But from a defense perspective, what is useful about identification of trade secret is that often the claimed trade secret is not much of trade secret at all. Once it's disclosed, one of the things that defendants deploy at that point is motion to dismiss, file a motion with the court like, this is disclosed trade secret, but in reality, most of it is publicly known information. That's one way to get rid of a case at that point. To me, it's trade secret is not really trade secret. But early disclosure of trade secret provides a very efficient means to end the case.
Yeah, you're absolutely right. But again, that's a powerful statement in the abstract. In practical terms, most trade secrets are described in ways that make them hard to shoot at. It's like trying to nail Jell-O to the wall. Even when you get a good identification, the breadth of trade secret protection is so much greater, and the ambiguity of what qualifies is so much greater than in the patent world that it becomes difficult to knock out trade secrets. I mean, from a defendant's perspective, one of the most frustrating things that a plaintiff can do is retreat to the combination trade secret argument, right? Where, oh yes, well, yes, you've identified that aspect in the public domain, and this one over here too, you can find that on the internet, but you can't find it all exactly as we have it in one place. And therefore we're entitled to move ahead, and fundamentally they are. Might not have much value, but so the prospect of actually getting things knocked out on summary judgment, unless of course you're in federal court where someone sees this as patent claim sort of thing, and they set them up and they knock them out that way. In state court, it's a vain hope most of the time.
Yeah, it's I have to say, like, I'm with you, Ken, on the need to kind of focus the case, but I think the reality is most of these come out as being morality plays, just straight out morality plays, where the jurors are not going to get quite as hung up on what is a trade secret or what isn't. They might fill in the form in a particular way, but if you interview it afterwards, they're going to be like, I thought that guy was a dirtbag. He shouldn't have been doing what he did. There's a bunch of bad documents that said where he appreciated the wrongfulness of his actions. I don't understand this trade secret stuff, but that demonstrates knowledge of wrongful conduct.
Yeah,
and patent cases can be morality plays, but not in the same way trade secrets can, right?
Well, you got to dig sometimes for the human interest in patent cases, but with trade secret cases, sorry guys, that's just the reality. But
I
trade
represent
secret
the inventor. Which side of the courtroom am I on today?
Yeah, right. And but in trade secret cases, they come with that there. I mean, it's like Joshua was saying earlier, the emotional content. I published a blog, you can find it on my website, a little over a year ago called I Learned Everything I Need to Know About Trade Secret Litigation in Divorce Court. And it's true. I did divorces at the beginning of my career, and it's extraordinary how comparable they are for that thing. But I've often said, when it comes to the kind of frustrations, Ken, that you're talking about, the reality is that a cup of bad behavior is probably worth 3 cups of technology when it comes to analyzing what's trade secret. The bad behavior will overwhelm the trier of fact when it comes to actually parsing the technology, unfortunately.
And I think one thing we're seeing unfold here as we see, at least particularly in the Northern District, some of the patent rules influence the level of detail required at the beginning of a trade secret case is, on the one hand, you have that requirement for detail and disclosure. On the other hand, it's not at all clear that it's going to be as hard to amend them, which is anybody who's dealt with these trade secret cases know is it can be well and good to get your 2019 disclosure and you think you're ready to go and you start shooting down all the trade secrets, and then 3.5 months later you get one that's 15 pages of new secrets and deleting 5 others, and it just starts to feel like whack-a-mole. And again, these are kind of the competing interests. But one thing that may develop is you could theoretically see judges saying, I want detail, but I am going to give you more leeway to change it later on if you find something new. That could potentially be a difference.
Yeah, and just like infringement contentions have not really, there was a lot of litigation about sufficiency of infringement contentions. They have not really acted as a barrier to discovery in a meaningful way in litigation. I think that's the way these trade secret IDs are going to play out too, because if you're in the Northern District and if you're with a judge that draws a higher standard, what people do is they write a phone book disclosure of all of the different things that they think are important to their business. It's very hard to challenge. They get the discovery and they say, I never would have imagined that they would have taken this one thing that I didn't include there. That's why I didn't include it.
Yeah.
Right?
And that can happen. That reflects the difference between litigating, and when we litigate patent cases, we're litigating over something that's fairly frozen in time and that is judged according to, fairly objective considerations. And trade secret cases are, they're a detective hunt for what happened and what's the consequence of it, and what to remember. It's a fault-based case. It's a tort. So, the expectations that we have about developing evidence and predicting what's going to happen in patent cases just don't port very well into the trade secret arena.
So Jim, let me ask you another unscripted question. Let's suppose you're a plaintiff and you brought a trade secret case and then turned out to be where defendant was somehow able to knock out all your trade secrets as belonging to a public domain. At that point, do you have a risk for a counterclaim of some sort of bad faith litigation or Rule 11 coming back at you?
Yeah, the law on this is more or less, so long as some trade secrets survive, the fact that some don't is not going to hurt you. On the other hand, if nothing survives, and there is evidence that this was competitively motivated, the courts have been pretty tough on assessing sanctions. Yeah.
I'm going to switch gears a little bit. This is a topic that I think the whole panel has comments on. Neil, I'll start with you, and it has a couple of different prongs, but obviously the impact of criminal prosecution on trade secret litigation, both kind of standalone, for lack of a better term, criminal trade secret prosecution, but also the threat of it when you've got a civil case pending, is certainly something that is coming more and more often, it feels like. I would love your thoughts on that, and I know the other panelists, likewise, from our earlier discussions, probably have some input there, but I thought I'd start with you.
Yeah, well, there are 2 different places where you can seek relief if you're a victim on trade secret misappropriation issues, where you want to get criminal authorities involved. You can either go to the state or you can go to federal. With the passage of the Economic Espionage Act, I think a lot of companies default to go to the federal. And it's interesting because a lot of the state folks, including the high-tech crime task force that's assembled here in the Valley, they're actually a little bit unhappy that people aren't coming to them with matters of significance to them. Now, on the plaintiff side, you worry a lot about sacrificing control and not being able to control how your trade secrets are portrayed in a courtroom. That's probably something better for you to talk about than me. On the defense side, when you have a client that is asserting the Fifth, being in federal or state court, which one you're in really, really matters if you're a defendant. If you're in state court, the evidence code says there is no negative inference, no inference at all associated with the assertion of the Fifth Amendment. That's state court in California. And basically, you're going to trial, you can take advantage of the fact that you have to treat this as if the witness were dead. Now, if you're in a jury trial, if your fifth asserter is in there, you're still going to pay a price tag. In federal court, there are negative inferences allowed. And just in the Waymo versus Uber case, Anthony Lewandowski, my client, was not even a party to the case, and the judge said, because he's asserting the Fifth, you can take a negative inference associated with him, even though he's not a party, but you have to decide what impact that has on everybody else that's in the case. And that's obviously in those sorts of situations, assertion of the Fifth to protect yourself and protect your own civil liberties, it's a very, very tough call to make, and it can have a whole lot of collateral consequences because Fifth Amendment assertions can extend beyond testimonial acts to what documents do you possess and the like, and creates a lot of difficulties on how do you develop narratives in your own case and defending it.
I mean, if you have an ex-employee who left your company, start a small company that competes against you, and your goal as a company is to have that person arrested, parade in front of the press to really kill that competition, I'll just go to state because your chance of a state attorney's office going along with that is far higher based on past experience, whereas I'm not sure that's the case with federal. But, as an in-house counsel, I have to manage risk. And so before you pull the trigger, if you're in-house counsel, please be careful because once you do that, and then let's say a person doesn't go to jail, or a person does go to jail, you have really ticked off defendant who's going to come after you. So when all these emotions die and 2-3 years later, you're spending a lot of money fighting these counterclaims that might come from this defendant, and then people are just going to ask you, what were you thinking 3 years ago? You thought that was great to have this photo op, but you're spending all this money, and we have enemy who cannot be consoled. So think about it, because when you try to put somebody in jail, that person is going to take it personally. You're threatening that person's liberty. Just think about that. So be very careful when you're trying to take advantage of criminal remedies.
And just to highlight the contrast that Neil mentioned, in California state court, what the law that Neil mentioned means is it's not just that there's no inference. You can't mention it. You can't talk about it. You can't whisper it. You don't get to talk about the assertion of the Fifth at any point. It's as Neil said, it's as though the person's just not there. It's a true empty chair. And contrast that with federal court, where I think inference or not, in some ways, and this goes to the point of just kind of jurors and common sense, you can put the person on the stand and force them to take the Fifth in front of the jury, even though you already did it in a deposition and everything else. And you can just go through that exercise. And so the difference that Neil mentioned in terms of the forum on this issue is incredibly stark.
Yeah, so that might be, there are not a whole lot of reasons to choose to go to federal court instead of state court in trade secret cases. The most important one is if you have interstate or international actors and you need nationwide service of process and so on. This may be another one. If you think that there is the involvement, or that there is the involvement of the authorities, the difference in how the Fifth Amendment assertion is played out could be a reason to go to federal court as a plaintiff. Otherwise, generally speaking, better off in state court.
Yeah. One other thing about the use or invocation of federal regulation of Economic Espionage Act, or trying to get the government to do something. Typically, when the alleged perpetrator is a foreign actor, in other words, their behavior is occurring abroad or is affecting something that the government could perceive as global competitiveness, you're much more likely to get the federal regulators interested in that. If you just look at the statistics, they're much more interested in going after Asian, particularly Chinese nationals and companies that they feel are taking U.S. trade secrets for their own benefit abroad. And part of the reason for that is because one of the factors that the federal government as well as the state prosecutors look at is, can this person get a good enough relief out of the civil case? If this is really something that feels more commercial and doesn't feel really criminal in the sense of something that affects a broader policy, they're not necessarily going to feel as excited about it. But once the trade secrets are going abroad, and to Jim's extraterritoriality point, it feels like there may not be a clear remedy for the company here, and there's this kind of national policy piece, you're much more likely to get them interested.
Yeah, there's no more than 10 or 12 maximum of these federal cases filed every year. So it's not a big sample size.
And if you have a trade secret that's stolen by your ex-employee who goes overseas, chances are that trade secret will be made into a product and export or import it into the United States, and you can go ITC, have an in-rem jurisdiction over that products, and if you win, you can get those products excluded. So if the feds are thinking that way, probably they're not going to cooperate with you. Whereas if it's something that maybe impacts critical technologies or national security, I'm sure feds will be a lot more interested.
Yeah, that, or if it hasn't happened yet. You know, if the guy hasn't left the country, then they'll get interested.
Let me just add one other thing about the criminal dimension, is that, I mean, there are times where the criminal authorities will get involved early, but very often they will want to wait for the case to advance, because the minute that there's a public awareness or a defendant awareness that there's a criminal investigation underfoot, everyone stops talking. And they often would rather have witnesses and potential defendants committed to testimony that they can test and evaluate to understand what the story is, to decide whether it's something worth pursuing. Because there have been way too many cases, right, where sometimes something looks really inflammatory, and then once the evidentiary record is developed in the civil litigation through means that aren't available to prosecutors, as well as witness testimony and defendant testimony, they could be wrong, and they really want to try and make sure they're getting it right.
Well, the burden of proof in a criminal case is beyond a reasonable doubt, which is far higher than a civil case. So if you're a prosecutor, you want to make sure that you have a ironclad case against the defendant, so the more evidence you can gather against that target, the better off you are.
Yeah. On the other hand, in criminal, you can prosecute attempted trade secret theft, and the trade secret doesn't even have to qualify as such. There are cases where they successfully operated a sting, and inside the box of that the accused thought contained trade secrets was just telephone books, and the court said, doesn't matter. He thought they were trade secrets, and so the crime's been committed.
Yeah, and for all the discussion we had about civil litigation and the need or battles over how precisely do you find trade secrets, in a criminal context, those rules really don't apply. Oftentimes in criminal Economic Espionage Act prosecutions, there are motions for something called a bill of particulars, which is a criminal way to get a trade secret identification, and not always, but pretty routinely those motions are denied. So the defendant is really faced with a conundrum on trying to figure out, based upon the Brady disclosures that are given, what are the actual trade secrets that are at issue and are likely to be tried. Now, you normally have witness statements from the companies, and there are various disclosures about what they're saying their important secret sauce is, but from a criminal defense perspective, you're often left much more in the dark.
Let's also talk a little bit, another topic where there's some kind of interesting differences that come up, particularly in the cases where you've got combined patent and trade secret claims as damages. And I think there's some often kind of misconceptions about how trade secret damages can and should work, particularly when things are coupled. So I want to make sure to give everyone here the chance to touch on some of those important differences. The ones that we talked about before this discussion really was that a lot of people, I think, believe that use is required in order to end up with a jury verdict. And that's something that's not actually, as a matter of law, completely accurate, but it's certainly something that has come up in articles about recent cases and elsewhere, so something helpful to discuss.
Well, I mean, from Inal's perspective, use is very important because I don't really care if, I mean, I do care, but I'm not as mad at the defendant, it turned out to be defendant is not using trade secret, because I actually had a case where I was representing a company whose ex-employee left and then used the trade secret to apply for a patent application. And then in the middle of litigation, it came out that my client wasn't really making use of that trade secret, neither was the defendant. So the end result was we had a settlement. So use, I mean, from business perspective, use actually does matter.
Yeah, so just to make sure we know the categories, there's acquisition, use, or disclosure of trade secrets. Those are fundamentally the three categories for which misappropriation can occur, although there's also threatened misappropriation and things like that. So one of the things that people are talking about quite a bit in the literature is whether acquisition, like if I just get a trade secret inappropriately, can that be a basis for the other side to get damages? And the theory on that is that when I acquire the trade secret, I am depriving the trade secret owner from having that trade secret, on its own in some way, and that somehow causes damage or unjust enrichment or some sort of damage valuation. In the Waymo versus Uber case, there were instructions and special questions on the verdict form that were saying, first you have to prove acquisition, then you also have to prove use or disclosure before there was an entitlement to damages. And if you read the literature, people say, oh, this was a really big deal because Judge Alsop said, this is what was inferred, that Judge Alsop said that mere acquisition does not entitle you to damages. That statement is false. Judge Alsop found in an earlier order that acquisition is a category where you can seek damages. But what he held was that Waymo had waived their right to seek damages on that basis. And so the instruction reads the way it reads because of this prior order that he issued, not because that was a statement of what the law was. And this is one of those things that it's easily misinterpreted when you look at those jury instructions and you look at the special verdict form, that it is held out to be something other than what the actual reasoning was to get there.
Yeah, there are actually at least two paths to getting damages for mere acquisition. One is, of course, to demonstrate damage to the trade secret holder. If you have exclusive possession and control over your trade secret, you can imagine that it has a certain value that is diminished if someone else who is not under your control gets access to it and has it as well. So that can be measured. Perhaps the easier and higher impact way of getting at the damage is to use the alternative form of unjust enrichment, which is available under trade secret damage law, straightforward principle that imagines what the defendant would have been willing to pay for it to get access honestly under a hypothetical negotiation. And that, depending on what the record is of the importance that the defendant placed on that kind of information, could be a very, very big number. And that's played out in a lot of recent cases that where the defendant has taken something that they weren't supposed to have, and they've more or less tried to commercialize it but fallen flat on their face. They really haven't actually made use of it, but they intended to. And there were records of their very ambitious, excited thoughts about where they were going with all this, and that information's been used against them to put a very high value on what they would have been able to pay, what they would have been willing to pay in a hypothetical negotiation. So you can get there. It's a little challenging,
things get really confusing as to what acquisition means too. Like, for example, if I took Ken's phone and I said, wow, the source code for that, the source code for this little camera, and I get a hold of it where I'm not supposed to, and I look at it, I go, God, that software, it's really complicated. I'm not going to use it. And then I develop a simple software to exercise a phone function. And I go out to market and I say, I have the simplest phone source code out there. Have I used his code or have I not? Right? Because I didn't actually put it to use, but I looked at it and I said, wow, they really have made life more complicated than it needs to be. I have a simpler solution. I think that type of example is the reason why there's a lot more flexibility in trade secret law.
Yeah.
And let's talk about that just a little bit to put some meat on the bones of that in terms of negative know-how and how that, again, plays out in these cases. Because as you point out, it's a little hard to wrap your arms around sometimes, and B, it is in many cases taking advantage of and claiming the benefit of essentially your mistakes in some instances. So let's talk about that a little bit.
Yeah, oh, okay. I mean,
You're the authority on it, Jim.
Yeah, well, look, I mean, people have, gotten upset about the concern that limiting use of negative information learned at one job will interfere with free mobility of labor and so on and so forth. And while it's certainly possible in some circumstances, the basic rule about in all states except New York, right, which still clings by its fingernails to the 1939 Restatement of Torts, where you have to, in order to prove a trade secret, you have to prove that it is in continuous use. But everywhere else, and under the Uniform Trade Secrets Act, the DTSA, information is protectable if it has actual or potential value, and that spreads most impactfully to the records of experiments in research and development efforts. So all of that data that is generated by experiments demonstrating what doesn't work or what works less well than others is the foundation for ultimately coming to a successful and commercializable product. Well, that foundation is something that a competitor would love to have because it would eliminate a great deal of time, effort, and risk in doing their own R&D and getting to a competitive product. And so modern trade secret law protects that, and by extension then, it does have an impact on people who leave having had access to that. If they go, Mr. Lewandowski, if he had gone to a place where the exact same technology path was being pursued, which apparently he didn't, he would be in a position of having to say, lead all of these engineers, and yet not say anything about when he knew that they were going down a hopeless path, right? And that's hard to do, but you need to figure out how to do it, and it's part of the risk management that one goes through when you're hiring high-level managers to ensure that they don't influence the process at another place that's essentially the same process that they've gone through somewhere else. So there are tensions involved here between legitimate competing interests, as there are in many other areas of trade secret law, and we deal with them.
Yeah, this is, one of the phrases that Judge Alsop used in one of his orders was, he says, must an employee give himself or herself a frontal lobotomy before they go to their next employer? Because there's an inherent tension between one's skills and experience, which is fairly, even outside of California, is fairly widely recognized as being, something that is encouraged and allowed, and something like negative know-how. And where do you draw the line between commercially valuable, sensitive, trade secret level negative know-how and skills and experience? And that issue, when it is a highly competitive mobile market, particularly in a technology space, I think it's less important in sales or areas like
Exactly.
that.
That's where it has the highest tension.
That area is a substantial employment act for people in this room, because that line is never going to be able to be clearly drawn because it is a discretionary call.
Right.
And Ken, in your experience in-house, does the negative know-how stuff end up mattering to you, or is it much more where somebody, to your point, is taking something that feels like kind of the next whiz-bang idea, or do you actually care about these negative know-how issues sometimes?
It's kind of ironic because I work for a company that actually did not have access to negative knowledge. For example, I think back in like 90s, there was a consensus almost within LCD industry that you cannot make a LCD screen that's larger than 40 inches. For some reason, the folks in my company either did not have access to that information or not, so they just march on and they made like 45 inches, 55 inches, and meanwhile...
Thank you for that.
Yeah, thank you for that, because in the process, essentially destroying the competition. So, negative knowledge can be negative. It can have negative consequences on you. But be that as it may, I mean, I think it is difficult to come up with a damages model when there is no use. I mean, that was one of the reasons why, in the case I previously mentioned that that we decided to settle, was that how do you come up with a number? I mean, so if you're really gonna have a negative knowledge case, you better hire Neil or Jim, because you need somebody who can walk on water to convince the jury that negative knowledge actually existed, and the one who acquired the negative knowledge has benefited from it, which is, I think, is fairly difficult to prove in a jury trial situation.
You need the broader narrative. You need the broader
yeah.
narrative, the
I
morality
mean,
play.
you need to make the Rosie Ruiz argument, that somebody jumping into a race near its conclusion has taken on, has appropriated an advantage that they shouldn't have. They should be required to go through the same experimentation as anyone else.
I think you need more than that, though, Jim.
I
think you need
it's necessary, but
some
not sufficient by
things that make
itself.
people look like they're bad people and not trying to be responsible with trade secrets.
Yeah, well, these days, honestly, and as we saw rolled out in the Waymo versus Uber case, a lot of the ambiguity attendant on departing employees gets resolved through forensics, where there is provable, downloading of massive amounts of information just before somebody leaves. And that, notwithstanding the fact that many other people have done this, and frankly, I've rarely found software engineers who will leave a place clean and let go of all the things that they have worked on in their life. That sort of thing really allows a narrative to be spun of terrible, immoral behavior, and pushes the case forward when the impact of the information itself may not be very great.
One of the more interesting things, if you look up, there's a Recode article that actually has the slides from the opening in the Waymo Uber case. We were out on summary judgment. I'll let you all try and figure that one out. But we were all out on summary judgment by the time the trial started. But they talk a lot about these 14,000 files. But the 8 or so trade secrets that were going to be at issue in the case, none of them, maybe one, but I don't think any of them were actually tied to those downloaded files. They were actually things that other people had talked about that had nothing to do with Anthony Lewandowski.
Right. But if you can get the jury,
But the narrative was the thing that they were focused on, right?
right.
So, Ken, you talked about some of the unintended consequences here. Somewhat related, there's a provision in the DTSA that was one of the few things that actually required some immediate and mandatory action on behalf of a lot of employers, which is if you wanted to protect your rights to recover certain damages, you needed to make changes to your agreements pretty quickly with employees. Ken, in addition to your point so far just about trends and what you're seeing so far. I'm definitely interested in your thoughts on the whistleblower provision, and I know Jim's thought about it as well, but whether or not that's coming up as far as you know for in-house folks, and if that's playing out at all so far. There's certainly a couple cases which we'll talk about, but interested in your perspective on that.
Yeah, so when DTS was passed, the talk of the town among in-house counsel was whether to change the existing employment agreement or not to reflect the changes in DTSA, because I think there was perception that if you don't change your employment agreement, you don't get the benefit of DTSA. And I think one of the challenges is that, when you go back to your employees and ask them to re-sign these employment agreements, it's usually you get lots of questions back. So I don't know how a lot of companies have came down with respect to existing employment agreements. I think the new ones, I'm pretty sure that most people have revised them to reflect whatever changes have been made under DTSA. But in terms of existing ones, your guess is as good as mine.
Jim, do you want to talk a little bit about how this has played out so far?
Yeah, I mean, really, we've had, the only provision of the DTSA that preempted state law was this whistleblower immunity provision, and basically came to be because of an article written by Professor Minnell pointing out that trade secret law was vague and weak around the public policy interest in allowing employees who had access to confidential information inside an organization to be able to report the existence of a crime to authorities. There were cases where when someone tried to do this, they ended up getting sued for violation of their non-disclosure agreements, even for sharing information with their lawyers. And so that led to an interest in the Senate and this exception, if you will, being introduced. And among other things, it required that notice be given of immunity. And there was but the consequence of not doing it was only that you don't get treble damages or attorney's fees against the employee. But so there was that issue, and as Ken has pointed out, it's awkward, and as a practical matter, a little bit difficult, but over time, it's going to take care of itself. As new agreements are signed, the language will be put in there. One of the more interesting things came up in the one case out of Massachusetts that has addressed how to interpret this issue. When you have an immunity, and Professor Minnell has written another article that criticizes this case, but when you have an immunity, the idea is you shouldn't have to spend any money on defending yourself in court. You should say, I am entitled to immunity. I cannot be sued. And usually that's easy to do because immunity derives from status. I am a federal whatever, and we can't be sued. Whatever the thing is. Here, however, the immunity stems from a factual proposition, that is, that the taking of the information and its delivery to the authorities for investigation of possible crime was done solely for that purpose. And the circumstances of the taking of information, sometimes when it's done very quickly, when an employee is on their way out, are more ambiguous. And so such was the case here. And the court was confronted with a motion to dismiss because of immunity on the one hand, and a motion for a preliminary injunction on the other, seeking return of the documents that this guy had taken. And the court said that he ended up deciding, yes, I'll issue the preliminary injunction and require that the documents be surrendered to the court. And denied the immunity because it thought the court considered that there was an issue of fact that couldn't be resolved on a motion to dismiss around whether or not the sole purpose was for this report to the authorities. Anyway,
you know what? I mean, whenever anybody raises immunity, there is going to be litigation. Like, for example, a police officer who is accused of violating somebody's civil rights is only afforded qualified immunity.
Qualified
So
immunity,
there
yeah,
will be a
but-
litigation over
But-
whether he or she is entitled to that qualified immunity.
Yeah.
And even like state government, like, for example, in the patent context, where the universities are afforded like sovereign immunity
Yep.
in terms of IPR. So is that?
There are always qualifications.
Yeah,
Right.
would there always be a litigation over immunity question?
I'm expressing here the concern that Professor Mandel has expressed, that immunity means, what it suggests. We're immune from litigation, and this interpretation may be a problem. I don't know how many of these cases we're going to see. However, I suspect, getting back to Ken's point about the impact, the practical impact on employers, I suspect that we're going to see more cases dealing with this immunity issue in the context of examining whether or not its assertion is a pretext, right? I've taken all of this, I only did it so that I could go talk to the feds, right? I didn't intend to use this to inform, my new startup business, and that I took, 10,000 files when the evidence of the criminal conduct is only in 3 of them. That shouldn't matter, right? I think we're going to see more of those kinds of things, but whether or not you can resolve immunity on a motion to dismiss, my own sense of it is that the judge in Massachusetts was probably right.
So a credit to my colleagues here is that we're actually running remarkably on time, and I wanted to make sure to note that if folks have questions, we're now in that last chunk where if anybody wants to raise them, you certainly should. Feel free to. Otherwise, we have really time for one more question for the group, which I think we're happy to do unless anybody has questions for any of the panelists.
So what provisions have companies made to protect themselves from loss of trade secrets? Has there been any policy changes in the way that employees work together, share information, and how this work gets distributed in such a way that no one group actually holds an understanding of the total scope of what is being treated as a trade secret? Because we hear that in the Valley, the way that employees work together, the way that they collaborate, particularly true in Apple, how employees really interact in ways that is quite distinct from other companies. And is that really being shown to be effective in protecting trade secrets?
So the question, which I'll just repeat to make sure everybody hears it, was what really are companies doing right now, given the realities we're talking about with modern technology in terms of siloing people or not siloing people in order to try and best protect trade secrets. Ken, I hate to put the burden on you, but this is one where you're probably unquestionably one of the more qualified folks to talk a little bit about what you're hearing and seeing without disclosing any trade secrets.
Well, I mean, typically, so yeah, as an outside counsel, this is what I used to advise my client is to make sure you take advantage of intake process. When you have a new employee, you make sure that the employee agrees that he or she is not bringing a trade secret from the previous employer to current work, and you emphasize the importance of respecting other people's IPs, and to the extent person has any IP that belongs to previous employer, you make sure that person lists up all those, and then make sure that person does not disclose that trade secret to your company. I mean, and then you emphasize to, again, on a yearly basis to make sure there's no commingling of knowledge. That's the best you can do, I think.
Yeah, I deal with these issues a lot in advising companies about their information security protection programs, and you raise an important point. There is no single answer to how to adjust this. There is a fundamental tension always between the imperative of sharing both externally and internally with people who might have a need to know, but you don't really know how far it should go, and security. You know, the most secure trade secret is something you don't tell anybody. You know, was it Benjamin Franklin said, 3 can keep it secret if 2 of them are dead, right? And so it's a matter of risk management. And Apple, the example that you have, you know, they encourage, you know, sharing and participation within a very small defined group that has to do with a particular project. There are other companies that, you know, believe in the value of very, very open sharing among people from different departments, et cetera. And for some of them, it's a cultural thing. But all of that sharing always comes at a cost and diminished security, and it's a question of how, you know, what's the level of threat and what's the value, and, you know, what are you willing to put up with in order to mitigate the risk? That's it.
Yeah, I'll just add two things. One thing that I think is often helpful when you're talking to employees about this that aren't necessarily lawyers is to follow a golden rule approach, which is, you know, if the trade secret that you have in your mind that you desperately want to, or the information you desperately want to share with your team, if that had been Apple's information and it was someone who had left and gone to Samsung, would Apple be happy about us sharing it? Would you do unto others as you would have them do unto you? And normally people can figure that out pretty quickly, that, okay, if I have this thing and someone might be mad that I would share it, then I'm not going to share it. The other thing that a lot of our clients do is, as part of just kind of the HR training that people have, they do have a component about what it means on intake and outflow of trade secret information, and just give very basic guidelines, maybe a couple hypothetical examples of, you know, circumstances where these sorts of things should arise. And they incorporate it as part of their overall training, so it's not as kind of intrusive or time consuming as it would otherwise be.
Okay. Thanks everyone very much. We managed to wrap up right on time. Thank you.